Just like I said when we talked about carry laws in the district back in late August, we're on the road again. Only this time the goalpost moved in a way that actually favors the Second Amendment. High-capacity magazines? Yeah, the scary label, are illegal under DC code if they hold more than 10 rounds. That's been the rule for roughly 17 years. And people get tripped up by it even when there's no other crime. Now the U.S. Attorney's Office is signaling a shift, no more standalone capacity cases. Here's the lay of the land. D.C. defines a large-capacity ammunition feeding device as anything that accepts more than 10 rounds. Period. If it's over 10, it's contraband. City officials have sold that as a violence reduction tool for years, leaning on talking points that mass shooters exploit big magazines to fire rapidly with fewer reloads. That's the script you've heard. Meanwhile, residents and travelers who own what most of the country calls standard capacity magazines have faced arrests simply for possession while passing through or living ordinary life. A little context helps. After high-profile incidents in the early 2000s and 2010s, several jurisdictions embraced capacity caps as a quick fix. California pushed Proposition 63, New Jersey dropped to 10, Colorado set 15, and Illinois added new limits in 2023. Whatever the number, 10 or 15, the theory never changes limit the box, limit the harm. The problem is that theory has to meet the Constitution, not just headlines. When lawmakers claim public safety, they still have to show the restriction fits our historical tradition. Enter the change. Prosecutors in the district now say they're not bringing standalone magazine cases, and they've moved to unwind at least one conviction tied to a 31-round mag. That's huge. And it's not happening in a vacuum. In 2022, the Supreme Court decided Bruen, which laid down a simple test if a modern gun restriction isn't rooted in the Constitution's text and the nation's historical tradition. It doesn't fly. No more vague balancing where bureaucrats wave charts and say, trust us, text, history, tradition. If the law can't clear that bar, the law should not be used to make felons out of citizens. Does that erase D.C.'s law? Last year, the D.C. Circuit still upheld the ban, and the code remains on the books. But what prosecutors choose to enforce is where the real-world pain lands. When charging policy changes, people stop getting cuffed for innocuous equipment, plastic and springs. That's not theory, that's your life, your car stop, your range trip. It also reins in government overreach. The power to decide whom to charge is massive, and when that power props up a rule that can't pass the Bruen sniff test, ordinary people pay first and argue later. I know what the other side will say. They'll point to studies claiming higher casualty counts when large-capacity magazines are used. I've read those. What never gets admitted is that criminals reload, defenders reload, and skill matters more than a number on a floor plate. Timed work shows competent shooters running 10-round reloads faster than sloppy bursts from a big stick. And the bad guy's intent, not the magazine, drives the evil. Meanwhile, gun homicide in the district is a human problem, not a parts list. Punishing hardware won't cure a sickness of the heart. So where does this leave you right now? If you live in or travel through D.C., this policy shift means less risk that a law-abiding person gets jammed up over a magazine today. It signals to courts and to the rest of the country, 14 states with similar bans, that the constitutional tide is rolling their way. Policy isn't a court order, and I want the statute gone. Still, this is a real step toward aligning words on paper with the rights you exercise, like share and subscribe to stay in the loop. The biggest win in a policy turn like this is clarity. When lawmakers draw lines that flip lawful gear into contraband at a county border, ordinary people carry anxiety like extra luggage. A charging shift states, in plain language, that standalone capacity is no longer the trapdoor, and that matters on the street, in a traffic stop, or at the range. It cools the air. People can understand the rule of the road and adjust, not as outlaws tiptoeing through a maze, but as citizens who finally see daylight instead of red tape. It is also a win for the idea that prosecutors answer to the Constitution, not the other way around. Prosecutorial discretion is not a loophole. It is a duty to avoid enforcing rules that collide with fundamental rights. After Bruen, the test is text, history, and tradition. In simple language, if government cannot point to a comparable rule from America's formative eras, a modern restriction has a steep hill to climb. You do not need a law degree for that. It is a common-sense filter show where we did this before, or stop pretending the experiment is lawful. There is a resource story here, too. Every hour spent processing a capacity-only arrest is an hour not spent chasing shooters who actually harm people. Paperwork, transport, court time, and discovery. None of that is free. When policy pivots away from low-yield, rights-fragile charges, investigators and prosecutors can put their shoulder into violent felonies, trafficking networks, and repeat offenders. That is not rhetoric. It is the hard math of limited time and finite budgets. Focus is a force multiplier, and clearing dead weight cases off the docket is how you get more justice for victims without hiring an army. Now, the counterpoint. Some argue that large-capacity magazines increase lethality in the worst events, and you will hear studies that try to tie capacity to casualty counts. Let us engage that without spiraling into a seminar. First, even serious papers acknowledge data noise, definitional fights, and confounders venue security, response time, attacker skill, and whether anyone shoots back. Second, capacity limits freeze the law-abiding while leaving the violent free to ignore them. Reloads are a skill, not a magic trick, and competent people move through them quickly. Policy that assumes a thin plate of metal will stop evil is comforting theater, not public safety. There is also the matter of proportionality. Capacity bans sweep in millions of magazines that are standard for modern handguns and rifles, the exact equipment that ordinary people use for training, practice, and defense. When the law recasts the ordinary as extraordinary, everyday life becomes a compliance drill. A policy that refuses to turn plastic and springs into a criminal case restores a basic sense of proportion and lowers the temperature between citizens and the state. It signals respect for peaceful possession, and it reduces the chance that a technical mistake spirals into a life-altering prosecution. The legal landscape still matters, because policy is not a judicial decree. The district's code has not vanished. A future administration should spin the wheel back, so the goal cannot stop at non-enforcement. The goal is to get bad statutes tested under Bruen and either struck or withdrawn. That path may run through federal district court, up a circuit panel, and, if splits deepen across jurisdictions, to the Supreme Court again. Meanwhile, other jurisdictions are watching closely. Where capacity bans exist, officials will either double down or quietly recalibrate. Either way, a charging policy that aligns with the Constitution sends a signal the culture is moving toward rights, not away from them. Stay tuned, because momentum matters, and the next steps will decide how permanent this progress truly is. We keep pushing until statutes match rights, not the other way around entirely. Skepticism is healthy, so let's address it head-on. You'll hear that capacity caps save lives in the worst events, and you'll see charts with trend lines and careful footnotes. I respect data, but I respect the Constitution more. And the rule after Bruen is straightforward if a modern restriction can't anchor itself in our nation's text, history, and tradition. It doesn't get to criminalize peaceful people. That isn't a loophole. That's the standard. It protects everyone precisely because it limits the government to powers it can actually prove, not powers it merely prefers. Policy is not permanent. A charging memo can redirect cases today and dissolve tomorrow. The statute still sits in the code, and the DCC circuit has previously allowed it to stand. That means there's daylight, but also shadow. The real objective is to get the law tested cleanly under the Bruen framework and either struck down or repealed. That can mean strategic litigation, preliminary injunctions for people in actual jeopardy, and, where appropriate, vacating prior convictions that rest solely on a magazine count. Until a court speaks clearly, you treat a policy like rain in the forecast, useful to plan around, foolish to rely on absolutely. Meanwhile, watch the ripple effect. States that built their policies on similar caps are paying attention. Illinois, Oregon, New Jersey, and California have all run versions of this play, and the cases are winding through trial courts and appellate panels. Some judges lean heavily on public safety affidavits. Others apply the historical test with real teeth. When different circuits reach different outcomes, the Supreme Court notices. That is how you get clarity for the whole country, instead of a patchwork that turns a highway into a legal minefield. A charging shift in the capital city is not just a memo, it is a message. There's a human side to this. 2. Capacity-only charges have turned routine stops into life-altering episodes for people who never hurt anyone. A plastic box and a spring shouldn't rearrange a life. When prosecutors step back from these cases, trust recalibrates. Officers can focus on violent actors, citizens can breathe without feeling hunted for hardware. That de-escalation matters in neighborhoods that already carry a heavy load of enforcement. It lowers friction and raises compliance, because people are far more willing to follow rules that don't treat ordinary tools as contraband. None of this means be careless. Know your local law before you travel. If your gear crosses jurisdictions, lock it correctly. Carry documents for peace of mind. And don't confuse a charging policy with a legal shield. If you end up in a bind, talk to competent counsel fast and keep training. Real safety is skill, awareness, and judgment. If something evil presents itself, your plan matters more than a number stamped on a magazine body. Practice reloads, practice movement, and keep your mindset calm under stress. Read the statute where you live, read the case law that binds your courts, and stay current. Let's also keep the doctrine digestible. Text, history, and tradition is not a museum rule, it's a liberty rule. The government must point to comparable, historically grounded limits, not just assert a modern interest. We've always drawn lines: felons, sensitive places, dangerous and unusual arms. But ordinary arms in common use are at the core of the right. That's why capacity bans run into trouble. They target ordinary equipment used by ordinary people for ordinary defense, turning routine possession into a paperwork crime. So here's the program. Push for clean test cases. Support plaintiffs with standing and the grit to see it through. Show up at hearings. Write your representatives. And vote in the primaries where most of these fights are actually decided. Keep conversations civil but firm. The culture moves when the quiet majority stops being quiet. Today's charging shift is a signal, and turn it into law, and turn that law into lasting respect for a right that predates our government and anchors our freedom. Like, share and subscribe so you don't miss what comes next.